Good morning, and thank you for joining our webinar today. Today's topic is on employment law in the UAE, a practical approach to legal compliance. My name is Rayhan Alim. I'm the managing partner and founder of Alpha Pro Partners. We provide accounting services, and very soon we'll be offering outsourced HR services. We serve the UAE, KSA, and UK regions. And I'm very pleased to be joined by two very talented lawyers in Nour and Natasha. Hi Nour, hi Natasha, how you guys doing?
Hi, Rehan. How are you?
Hi Natasha, how are you doing?
Hi, great. Thank you. How are you?
I'm good, thanks. So Nour is the co-founder of Lex Consortia. Lex is a fast-growing UAE-based legal consultancy that's reimagining legal solutions for the corporate world and in the GCC region. Nour envisions the company to break records in employee and client satisfaction in the legal field. She brings a wealth of diverse expertise and knowledge and has a unique background in the field of human rights at the South African Human Rights Commission. She's also worked for the Big Four and for the UAE Government Regulatory Authority. Natasha is a junior corporate and commercial associate at Lex Consortia. Her expertise lies in supporting startups and small to medium-sized enterprises in the employment law field. So before handing over, we will have a Q&A session at the end. So please put your questions in the comment section and we'll read them out. This webinar is also recorded, so it will also be shared on LinkedIn, so you can find it there as well. So without further ado, Nour and Natasha, over to you guys.
Thank you so much, Rehan, for this introduction. And we are very pleased to be here with you. And I want to thank all the attendees for also joining us today. And just before we get started, really, I want to lay out the base in terms of how we're going to be doing this. So, of course, we are all very well aware of the fact that the employment law has changed, major change really that happened about a year ago. So what we want to do in terms of this webinar to make sure that you get the most out of it really is to take a very practical approach to the changes that have been made. So what we are going to be doing is that we're going to address different aspects of the law that have changed, that have to do with different parts of the employment cycle. We're going to be addressing them in an FAQ type of questions. And we really are going to be laying out very practical aspects that you can make sure to incorporate. So Natasha, if you can get us started, please, with the first question. All right, so when did the new law come into effect? So as we mostly all know that the new federal decree, which is law number 33 of 2021, came into effect in February 2022. Now, that again is almost a year ago. So there are other changes that have actually been made during that period. And that's what we really want to focus on, specifically in light of the grace period that has been given to companies. So the law itself came into effect Feb 2nd, 2022. The grace period that was given only has to do with the changing of the contracts. So for everyone to be clear, the law itself has been effective for over a year, and the only aspect that is subject to the grace period is us changing our contracts, all companies changing their employment contracts to be in adherence with the new law. So before we get into more details, just an overarching principle that we want everyone to be very well aware of when you're dealing with employment matters going forward, whether you're a business owner, HR professional, or in-house legal counsel. The overarching principle of the law and the changes that have been made are to benefit the employees. And you would see that very clearly in the changes that were made. So just be mindful of that in your decisions, and be mindful of the fact that the law itself actually stipulates that if your old terms of employment are more beneficial than the new terms of employment, then you're not going to be allowed to change the terms to something that is, again, less beneficial to the employees. That basically means that the authorities are not really giving space for companies to abuse the fact that there's been a change in the law, which means that we all have to change our employment contracts. So we can't really take that as an opportunity to give employees less benefits. So let's say, just to give a very small example, if you're a company and you were giving your employees 30 working days as annual leave, which is more than the minimum, which is 30 calendar days. So in changing your contracts, you can't then opt to changing it to 28 working days, for example, because that is less beneficial. So again, just an overarching principle that will be relevant to all the aspects that we discuss. And just noting that the grace period for changing your contracts has been extended. So it was 1 year, which means that it should have expired in Feb 23, but they've extended it till the end of the year, i.e. 31st December 2023. Moving on to our employment contracts, Natasha, please.
Thank you, Nour. So adding on to what Nour was saying about the employment contract, our second question is, are unlimited term contracts still valid? And when should we start shifting the employment contracts? So just to answer that question briefly, unlimited term contracts are not valid anymore, and you should start shifting them as soon as possible. So the new law has eliminated the unlimited term contract and introduced a specific term contract. And they've added in the law a cap, a maximum of 3 years. So the specified term contract should not be more than 3 years. However, recently, a couple of months ago, the authorities have actually removed that cap as long as the term is specific. So that means that the employment contract can be either 3 years, it could be 70 years, theoretically. But it's important to note that in practice, the Mohre contract, which you would have to get issued in Tasheel, right now, they only provide 2 years contracts. So it's really important to always keep in check with the authorities with Tasheel to see if they have updated their systems. And moving on from that, we always advise companies to renew their contracts, their employment contracts, even if there's an automatic renewal clause, for example, in the internal contract. As soon as the time comes that you need to renew the contract, for example, the Mohre contract, you have to go to Tasheel and get it done in writing by signature. And we also advise the renewal of the internal contracts to go in line with the Mohre contract. So even if, for example, in the internal employment contract, you have an automatic renewal clause, which means that if no one basically provides a notice that they don't want to renew the contract, and then the contract just keeps on going automatically, we advise our clients to always sign and renew the internal contract in line with the Mohre contract so that it can be upheld in line with the Mohre contract in case of any disputes or if, the matter is taken to court. Moving on to the next topic.
Now, the next topic, which is work permits and patterns. The question that we've raised here is, what are the new types of work permits and patterns that have been introduced? Now, this is a major change, really, that we can see that shows us how the UAE is really trying to be in line with global trends and how we've seen, obviously, during COVID, remote working, flexible working and whatnot. So they have introduced a number of categories for work permits, such as temporary permits, one mission permits, juvenile, student, golden visa, national trainee, and freelance permits. So all of these permits didn't exist beforehand. What we did have was a full-time permit and a part-time permit. So you can see the big difference in terms of the options that are given right now, as well as the fact that other than the permit itself, they have also bifurcated and given options for work patterns. So we do have 4 options for work patterns now, which are temporary, flexible, remote, and job sharing, which also obviously gives companies as well as employees a lot of options, which will enable them to actually have the proper contract and permits in place that do reflect the accurate engagement that they have. Moving on, in terms of working hours, they also have introduced remote working as well as different working hours, which means that you don't have to have the same working hours for the whole week. It can change, again, showing the flexibility and adopting different work patterns. Now, one last point that we want to make in terms of the different work patterns is that previously, UAE companies were only allowed to pay their employees a salary in the UAE national currency, i.e. the dirham. However, now it is allowed and permitted for companies to pay their employees' salaries in different currencies. So again, adopting and making it a lot more feasible for international companies that have presence outside of the UAE. Now, to be very practical, as Natasha already mentioned in terms of the contract durations, these permits and patterns are not all currently active with the authority as of now, which means that you will still have to regularly check with Tasheel just to ensure that once the relevant permits and patterns that you need are available on the system, that you can go ahead and benefit from them.
Moving on to the next topic, which is probation and notice period. Our question is, do we have to give notice of termination during probation? And are we entitled to compensation in case the employee resigns during probation? In the previous law, the company was not obliged to give notice when terminating an employee during the probation period. However, this has changed. Now the company, if they want to terminate an employee during the probation period, they need to give a 14 days notice. However, this changes if the employee wants to resign during the probation period. And there are two circumstances that come into play. Whether the employee wants to stay in the UAE, which means they are moving to another company, another job, or for any other reasons they stay within the UAE. And the other circumstances if they decide to go back home to their home country. So if the employee decides to stay within the UAE, they need to give the company a 30 days notice. And if they decide to leave the country, then they have to give a 14 days notice. Mentioning that, if, for example, the employee hands in their notice, they're saying they're going back to their home country, and then there's a last minute change and they get an offer in the UAE and they want to stay, they would be liable to compensate the company the remaining number of leaves, as though they would be providing the leave if they were within, like, staying in the UAE. So this is called the notice period allowance. So to give an example, if an employee says that they are going back home and they want to leave during the probation period, they give their 14 days notice, and then maybe one day before their last day, they get an offer and they decide they want to stay, or even after the notice period is over and they end up staying in the UAE, then they would be liable to compensate the company the remaining, which is 16 days, so that it becomes a total of 30 days to the company. And also to add to that, the law actually introduced that if an employee leaves or resigns during the probation period, the company would be entitled to receive compensation for onboarding costs. Onboarding costs means any visa fees, any external trainings that were provided to the employee during probation period. However, the authorities have highlighted that this process would be handled by the authorities directly, so Tasheel in this circumstance. But the thing is that it's very important to keep all these onboarding costs and external trainings documented and to have a paper trail. So definitely keep your receipts so that you can provide them to the authority if the time ever comes. And also it's important to note that although that this has been introduced in the law, it is still not active with the authorities. Just to give a brief background, the previous law was enacted in 1980, which was a very long time ago. So this highlights that the authorities will require some time to get up to speed with the new concepts that they are introducing. I just want to quickly mention that in terms of leaves during probation period, So employees are not entitled to annual leave during the probation period. However, the company can grant them if they are requested by the employee. But some practical advice in this topic is that if you do grant annual leave to the employees during probation, then they will be entitled to have the rest of the accrued and unused leave. So if, for example, you give an employee during probation 2 days leave and they decide to leave after 4 months, that means that they would be entitled to 6 days of leave because they're entitled to 2 days per month, and you would have to compensate them in lieu of the unused leaves. However, if you don't grant the leaves during the probation period, then if the employee leaves during the probation period, you would need to compensate them in lieu of those leaves. Speaking of leaves, on to the next topic. Our question is, what has changed with the existing leaves, and are there any new types of leaves? So in terms of the existing leaves, which is the annual leave, the sick leave, and the maternity leave, there has been some changes. In terms of the annual leave, it's still a minimum of 30 calendar days. However, a new concept was introduced, which is being able to carry forward at a maximum of 50% of the leaves to the next year. This is also based on the company's approval, so the company can decide if they want to introduce a carry forward policy, they can. If not, then that's fine. We would advise companies to decide on a number of leaves to be carried forward. In practice, we see a lot of companies choosing 5 leaves to be carried over. And that also brings into light that it's really important to plan your employees' leaves, because at the end of the day, unused leaves are still owed to the employee. So whether they use them or not, if they don't use them, the company would still have to compensate, whether it is after 1 year or in the final settlement. So we would suggest to plan your employees' leaves and consciously make a decision whether it is commercially viable for you to, instruct your employees to take leave with giving them 30 days notice, or whether compensating them in lieu is more beneficial for your company. Moving on to sick leaves. So the number of sick leaves are still the same: 50 days full pay, 30 half day, 45 unpaid. The change is that the employee needs to notify the company within 3 days. The change from the previous law is that you needed to notify within 2 days. And also another change is that employees are entitled for sick leave directly after probation, whereas previously it was 3 months after probation, so after 9 months. In terms of maternity leave, they have increased the maternity leave from 45 to 60 days. So the breakdown of the 60 days is 45 days at full pay and 15 days at half pay. And they've also introduced a few other concepts, such as if the employee experiences a premature birth, she would still be entitled to maternity leave. And also if, God forbid, the employee experiences some illness directly due to birth, or her newborn is sick, then they would be entitled to an additional 45 days of unpaid leave. And then the law has introduced 3 new types of leaves: bereavement, parental, and study. Bereavement leave is in case the employee's spouse passes away, or in case the employee's children or other family members pass away. The employee would be entitled to a certain number of leaves. So in the case of spouse, it would be 5 days. And in the case of children or parents, grandchildren, grandparents, siblings, it would be 3 days. For parental leave, it's along the same lines of maternity leave. The employee gets 5 days, whether you're the mother or the father. And for study leave, in case an employee is studying at a recognized institution, it needs to be recognized by the Ministry of Education. Then you would get 10 days. Of course, this needs to be approved by the company. 10 days of study leave, either to sit your exams or study for them.
Perfect. So next we have the topic of disciplinary actions. And I would really say that this is one of the most problematic topics that clients generally face problems when it comes to it, especially if it does lead to termination. So the question that we have raised here is, can we terminate an employee immediately without notice? So the answer to that is yes, as long as it's subject to the Article 44 of the law, which basically has is the equivalent of Article 120 under the old law. Now, in order to be able to do that, in terms of terminating without notice, there is a specific process of escalation that needs to have occurred, which we are going to go through now. But before I do, what I wanted to mention is that the purpose of disciplinary sanctions and actions is not termination. So generally, the purpose is for you to have a system to be able to take certain actions against employees, the extent of which and the severity of which depends on the breach that has occurred, not with the purpose of termination. So termination in this case can be a consequence if the matter escalates, if you take the correct disciplinary actions, escalated enough, and then you reach a point where the employee has not rectified, they have not basically switched over their performance, and at that point you might decide to terminate the employee with immediate effect. But again, that is not the purpose of the disciplinary action. So just to lay out the types of actions that are available, because there have been changes in the sense of certain actions that have been introduced that didn't exist beforehand, and other actions that were already there that have changed a bit. So if we take the first disciplinary action, and I'm going to be mentioning them in order of severity. So the first one would be a written notice. The written notice is a new type of disciplinary action that did not exist. And just for ease, you can really look at it as a verbal warning that's in writing, which might not make sense to a lot of people. But if you think about it, the whole point of having it be in writing, even though it is not meant to be a written warning, which is a different category, is to at least to be able to document that that initial action has been taken, because the verbal warning can then come down to a he said, she said, right? So you have the written notice number one, which is the equivalent of a verbal warning. And then if you want to escalate, you can then issue a written warning. Now, the written warning did exist beforehand, and the process of escalation here is that you can issue 2 written warnings. So you issue the first one, and then you give a period of observation. Let's say you want to give 3 months, 6 months, or whatnot. And if within that period itself there is another breach, you can send out another written warning. And then if after this period of observation the breach has not been remedied, the performance has not changed, then you can issue a second written warning. Now, from the written warning, you can go directly to a third warning and then immediate termination. Or you can continue to escalate, because there are different other disciplinary actions that have been provided. And the ones that I will be mentioning from now onwards don't specifically have an order. The law has really given companies the choice in terms of which action they would decide to take. So firstly, we have suspension. And companies can suspend employees 14 days without pay. The old law only allowed for 10 days with reduced pay, so that is one change. The second action that can be taken is depriving employees from their promotion, and that has a limit of maximum 2 years. So you cannot deprive an employee of their promotion for more than 2 years. Next, we move on to dismissal with end of service. So previously, Article 120 basically allowed companies to dismiss employees without end of service, and that option is now not available. So even if you are to terminate an employee with immediate effect in line with the process of disciplinary action and documentation, you will still have to pay them their end of service. Now, before we move on to certain other points that we want to mention in terms of disciplinary action, what I do want to really highlight and stress on is that when it comes to disciplinary actions, the most important thing is documentation. And when I say documentation, I don't just mean in terms of documenting the action itself in the sense of the written warning. No, what I do mean is that we've seen it to be very helpful for companies to have a very systemic and clear process and progression of disciplinary actions that is available to their HR professionals and employees too, to make sure that the disciplinary actions and the process of the same are available to everyone, they're clear to everyone, and to make sure that you as a company follow that process that you've adopted, which is in compliance with the law, and that you follow it with all cases, not on a case-to-case basis. So I've already mentioned that there are certain disciplinary actions that are left to the company to decide in terms of when they want to use them. But other aspects of disciplinary actions, such as the written notice and the warnings, have very specific requirements. And that's why we think it is best to really have a very clear process of disciplinary action internally within your company, so that if in case one matter does end up being a dispute, which does happen a lot of the times, especially with disciplinary action and immediate termination, if the matter is to go to Mohri through a labor complaint or then after to court, the most important thing will be for you to be able to show that paper trail that proves the escalation and your compliance with the law. Now, if we move on, our next topic is termination. So the question we've raised here is, does the company need a reason to terminate? And does end of service gratuity entitlement depend on which party terminates the employment? So the answer to the first question is that no, the company does not need a reason to terminate. And that is part of the shift from unlimited and limited contracts to a specific term contract. The requirement, though, is to make sure that you do serve the agreed upon notice period, which would be between 30 to 90 days as per the law, depending on what the contract stipulates. And once the company, if it's from the company's side in terms of termination, then the company would need to provide the employee with 1 day of unpaid leave per week for the purpose of looking for another job. And of course, the employee would need to give a prior notice of the day that they do require. Now, in terms of end of service, the change that has happened here is in terms of entitlement and not really the calculation. So what we do see is that they have left the same calculation of end of service that was applicable to limited contracts previously, which is at basic wage, 21 days each for the first 4 years, and then 30 days after 5 years. Now, the change here is that that end of service calculation applies to all contracts, all employees, because now we only have one type of contract, which is this specific term contract. And the end of service entitlement is not affected by the party who has terminated. So whether it's the employee or the employer, the end of service would remain the same. However, one change that does depend on the party that has terminated the contract is the annual leave compensation. So for unused leaves, now, in case the company has terminated, the unused leave balance will be paid on gross salary. However, if the employee has resigned, then the unused annual leave balance will be paid on basic salary. So on a practical note, what we do want to really stress on is to make sure also that you do have a system of exit formalities in terms of when you calculate your final settlement, when you actually pay the employee their final settlement, when the handover documents are signed, as well as the visa cancellation. Now, if we move on to our last topic.
Thank you, Nour. So this question is, what other major obligations related to employment that we need to comply with? So the authorities have introduced one new concept called the involuntary loss of employment insurance, also known as the unemployment insurance scheme. And this was introduced in September 2022. And it is the responsibility of the employee to register and pay the premium in order to be protected in case of termination by the company. And this is a mandatory requirement. The employees must register before June 2023 to avoid getting fines. So in terms of a practical some practical advice is for employers to educate and inform their employees and ensure that they are registered on time. And basically, in case of termination, but this does not include termination for reason of disciplinary actions, the employee would be entitled to receive 60% of their basic salary if they have been subscribed for the insurance for at least 1 year. And they would get this compensation for a maximum amount of 3 months at a time. And this gives them the chance to look for another job comfortably with a stable income coming through, even if they don't have a job. And the registration for that would be directly through the ILOE website. And yeah, it is recommended for employees to start registering as soon as possible. The next obligation is, I'm sure, well known in this region, the amortization, which basically stipulates that for every 50 employees, if a company has more than 50 employees, there would be an amortization rate of 2% of the skilled workers, which means for every 50 employee, one national employee needs to be hired. And it's important to note that if companies do not fulfill this obligation, they would be subject to a fine, a penalty of 6,000 dirhams per month for every Emirati that is not employed. So, for example, if a company has 100 employees, then based on the Emiratization rate, they would need to employ 2 Emirati employees. And if they do not, they would be liable to pay 12,000 dirhams of fine per month until the Emirati employees are hired.
Thank you very much, Nour and Natasha. That was a very informative and very useful session for us all. We'll go into Q&A right now. I can see there's quite a lot of questions that have been asked in the comment section. Before we go there, I just want to ask one question selfishly from my point of view. So a lot of the presentation was, I guess, you kind of alluded to Tashil, and so a lot of the kind of regulations, correct me if I'm wrong, relates to mainland, but I know there are sometimes subtle differences for free zone. Can you just clarify if there are any differences between mainland and free zone?
Sure. So yes, Rehan, as you said, we did focus on mainland. Now, just for clarity, the federal law applies to all companies, mainland or free zone. Of course, when in saying that, we're not including DIFC companies that are subjected to a very different law based on common law. But even for free zone companies, they are subject to the federal law. What you would see in terms of differences is that there are certain free zones that have their own employment regulations, which would fall under the law. They're not on the same level in terms of weight. They're based on the law. They might be a little bit more detailed. But for example, Javza is one of the free zones that does have employment regulations. So Javza itself would then also expect you to comply with the regulations in addition to the federal law. So the law still applies. And then in terms of the relevant authority for employment, so yes, Mohri is the relevant authority and coming out of that Tashil for mainland companies. For free zones, again, there are different situations. For example, Javza does have its own labor department, labor office. Other free zones basically deal with tasheel, for example, or Mohri from the back end, but they just allow you to submit through them. They don't necessarily have a full-on separate labor department. So that will depend from one FISM to another. But again, the law applies to all except the IFC and common law jurisdictions within the UAE. What you might have on top of that is the free zone's own employment regulations.
Yeah, that's really interesting to know. So thank you very much for that. I'm just going to run through some of the questions asked in the comment section. And obviously, some of these questions could be quite detailed, and some of them you may need to take them offline. So feel free to mention which ones you want to take offline. We don't really have that much time left. So we've got about 10 minutes. So I'll just quickly run through some of the more straightforward ones. So there's a question about commission agent jobs. So I guess what this person's asking about is there are some agents who are on a commission-only basis, I guess. Do you mind shedding some light in how that would be treated under the law?
Sure. So practically speaking, because this is something that we've also had to deal with, the authority doesn't really recognize, or it doesn't have a specific contract that is commission based only. What you do have the option to do is to have a very minimal lump sum monthly salary, and then on top of that you can have commission. But there isn't a purely commission basis contract that is available with the authority.
Oh, okay. No, that's great to know. Another question is, I think this is quite straightforward. I guess as a clarification, is the company charging the onboarding cost to the new employer or the employee? So I guess this goes back to the point that you mentioned about someone leaving within their probation.
100%. That's a very good question. The answer is it's charged to the new employer, and the mechanism that they have laid out as per the law, which unfortunately we still haven't seen being laid out in practice, which is the fact that this reimbursement is meant to happen between both companies, both employers, old and new, through the authority. So the company is not going to go out and reach out to the other employer. So this is meant to happen through the authority, as they are able to keep track once they're issuing a new work permit for an employee. And if they do have the record that that employee has resigned during probation, then that reimbursement will happen through the authority directly, not from the employee, and not directly from one employer to another. But as I said, Rehan, because we've not seen that practically happen yet, that mechanism is not there. So what we have seen, practically speaking, is that companies have opted for now to mention that these onboarding costs would be due from the employer or the employee, which we would not advise on, because as per the law, this reimbursement is meant to be paid by the new employer. I hope that answers the question.
Yeah, thanks for that. I've got two similar questions, and it's all to do with the annual leave. So the first question is, do we still mandate that they use their annual leave even if they have a carryover policy? Second question is, some companies lapse the annual leave if they don't take it within 2 years. Is that allowed?
Okay, I'm going to answer the second question first, because that's something that we always try to highlight as much as possible. Companies need to know that the leaves do not disappear, okay? If the leave lapses and the carry forward has already been for 2 years and they're not able to carry it forward even more, which means that the employee cannot use it, the company will have to pay the employee. So for companies to understand and HR individuals to know, there are only two options when it comes to leaves. Either the employee uses them or they get paid in lieu. Now, the difference in terms of timing has to do with when you'll be able to have whether both options or just one. So for example, if I'm planning my employees' leaves, and that's to answer the first question too, even if I'm allowing them to carry forward, because I know, for example, if as a company we've decided that we want to allow employees to carry forward only 5 days of leave. So if I ask them to plan their leaves in advance and to make sure they take their leaves minus the 5 carry forward that they want to, that means that I will avoid having leaves that I have to pay them in lieu. Because if they do not end up taking the leaves other than the carry forward, then I have to pay them. Now, companies can either pay in lieu of the leaves, unused leaves, either on a yearly basis or at the time of final settlement, That at the end of the day is up to the company. Most companies opt to pay it at final settlement. However, again, they do not just cease to exist. So please make sure that you either make sure that the employees take their leaves, or that you're accounting on the fact that you're going to have to pay them in lieu of these leaves.
No, thank you very much for that. I've got another question. It says, is a mother eligible for 5 days parental leave apart from the maternity leave?
Yes.
Exactly.
I'll take ahead. I'll answer this question.
Okay.
So basically, the parental leave is in addition to the maternity leave. But the limitation with that is that this parental leave, needs to be taken within 6 months of the newborn's birth. So whether you're a mother or a father, you are entitled to these 5 days within 6 months. And it doesn't matter whether you have taken your maternity leave or not.
Okay, great. Thanks for that. Same person asked another question, but I think you want to take that offline. Is if someone's contract is still not converted from unlimited to limited, is the end of service gratuity as per the old unlimited contract or as per the new unlimited contract? I think that's quite a complicated question to answer. So I think you might want to, whoever asked that question might just want to reach out to Nour and Natasha offline.
I would ask them to reach out, because the answer to that question is not as straightforward. It
Yeah.
depends on when the contract is expiring, pre or post the grace period. Because if it is post the grace period, then it's gonna have to be calculated as per the new law. So yes, I would please request the person that is asking this question to reach out to us so we can discuss this in more detail.
That's fine. I think we'll just take one more question and then we'll do the final kind of thoughts. There's one about overtime calculation. I know overtime can be can be quite complicated, but is it the same person that's asked to elaborate on overtime calculation? Is there anything that you guys want to just mention about it that we as employees should kind of be aware of?
So I'll mention one thing first, and then I'm going to ask Natasha to also elaborate on that if she has anything that she wants to say. So the total, in terms of overtime, the total working hours need to be a maximum of 144 hours every 3 weeks. So that's your cap. Okay. So Natasha, if you want to elaborate on that even more.
Sure. Thanks, Noor. So, as per the law, overtime should not exceed 2 hours per day. And the working hours are 8 hours a day. So, the employee should not be working more than 10 hours per day. Although in practice, that's not practiced. But in terms of the overtime calculation, the calculation breakdown is the basic wage plus 25% of the basic wage on top of that, so a total of 125%. However, if the employee is working overtime between the hours of 10 p.m. and 4 a.m., then the overtime pay increases by 25%, so it would be a total of 150% increase. In addition to that, if for any reasons the company requires employees to work on a weekend or a public holiday, then they have the option to compensate the employees with another day off, or compensation in lieu, which is based on 150% of the basic wage.
Cool. No, thank you. Thank you for that, Natasha. It's been a really great session. Thank you, Nour and Natasha, for providing your insights and answering a lot of the questions. If you want to get in touch with Lex, their contact details are there. Feel free to use the QR code to get in contact. Nour and Natasha, any final closing words from either of you?
Yes, please. Before we do that, what I do want to do is we want to offer all our attendees an opportunity to get access to an FAQ that we're going to be preparing and sending over within 24 hours of the webinar, that will answer more questions in a bit more detail. So whoever of the attendees is interested in receiving that FAQ, please let us know in the comments so that we can make sure to get it over to you.
Yeah, that'd be great. Thank you very much for that.
No worries.
So, so Natasha, any final words from yourself?
I would just say to company owners, HR individuals, just be on top of the employment obligations, and to not be afraid to just give us a call if you have any questions, and also to just regularly keep yourself updated on any changes, because as we have seen, the authorities are just bringing in new changes just to get themselves updated and to be in line with the new law. So yeah, that's just that's my last piece of advice.
I'll say another final word before we close up. I'm so sorry, just on that. And Natasha's already mentioned that, but again, this new law is coming after a very long time. The previous law was there since 1980, which means that not just the authorities, but even us as professionals, whether legal professionals, HR, business owners, or whatnot, we really are extremely used to a certain way of doing things, especially when it comes to employment. Certain things are very automatic, whether it's end of service, annual leave, etc. So please be very conscious, because as we said, the law has been effective since over a year now. And even if you as companies may not feel that difference, because the only tangible thing you might really be seeing is the change in the contracts themselves. But in case there's any dispute and it does go to the ministry or to court, you will be held liable to make sure that you were in compliance with the law. So please be very conscious not to do things automatically. Things have changed. And of course, just make sure that you update your handbooks, your policies, and we are always there, and also please to be of support if you need anything.
Cool. No, thank you very much for your time, Nour and Natasha.
Thank you.
Thank you everyone for joining us today. Like I said, this session is recorded. It will be available on LinkedIn. We'll also share it as well on our socials. Thank you very much. Have a great day, guys.
Thank you.
Thank you so much.